What if I told you that a company convicted of bribing doctors to prescribe drugs that killed people can't be sued when their products hurt you? Or that a company that paid billions for targeting elderly dementia patients with dangerous drugs has complete immunity from lawsuits? I bet you didn't know that pharmaceutical companies have paid over $126 billion in criminal penalties for fraud, bribery, and falsifying safety data, more than any other industry in history. Yet these same companies, and only these companies, have something no other industry in America has ever received: complete, legal immunity. Let me explain what this means in simple terms. If Toyota's brakes fail and kill your family, you can sue Toyota. If McDonald's food gives you E. coli, you can sue McDonald's. If a toy company's product injures your child, you can sue the toy company. But if a pharmaceutical product that's literally mandated by the government injures or kills someone, you cannot sue the manufacturer. Instead, you have to go through a special government court with no jury, sealed proceedings, and a $250,000 cap on death claims. This protection exists for one industry and one industry only, the same industry with the longest criminal rap sheet in corporate history. Let's start with Pfizer. According to the Department of Justice, Pfizer has paid $11.26 billion in criminal penalties across 107 violations since the year 2000. In 2009, they set the record for the largest healthcare fraud settlement in history, $2.3 billion for illegally marketing Bextra and paying kickbacks to doctors. The Department of Justice literally said Pfizer was a, quote, repeat offender that showed, quote, blatant and continued disregard of the law. Just this year, 2025, Pfizer paid another $59.7 million for paying kickbacks through their subsidiary Biohaven. They never stop. Now let's talk about Johnson & Johnson. In 2013, they paid $2.2 billion for illegally marketing Risperdal to elderly dementia patients and children. The U.S. attorney said, quote, J&J's promotion threatened the most vulnerable populations of our society: children, the elderly, and those with developmental disabilities. AstraZeneca, they've paid $1.96 billion in penalties across 33 violations, including $355 million for conspiring with doctors to defraud the government by billing for free samples, and $520 million for illegally marketing antipsychotics to children. Merck paid $671 million for bribing doctors with what prosecutors called, quote, illegal kickbacks disguised as consulting fees. They had 15 different bribery programs running simultaneously. Let me put this in perspective. These companies have been convicted of falsifying drug safety data, hiding deaths in clinical trials, bribing doctors to prescribe dangerous drugs, targeting vulnerable populations with unapproved medications, defrauding Medicare and Medicaid, creating fake medical journals, ghostwriting studies. This isn't conspiracy theory. These are federal convictions and settlements where companies either admitted guilt or paid massive fines to avoid prosecution. So how did the most criminal companies in history get immunity? It happened in 1986 with the National Childhood Vaccine Injury Act. But here's what nobody talks about. Even President Reagan didn't want to sign it. In his official signing statement from November 14, 1986, Reagan said, quote, I have serious reservations about the portion of the bill that would establish a federal vaccine injury compensation program. He went on to say, quote, despite these concerns, I believe that the benefits outweigh its defects, and therefore, with some reluctance, I am approving the bill. Reagan called it an unprecedented arrangement because it had, quote, serious deficiencies. Think about that. Unprecedented means this had never been done before in American history. No industry had ever received blanket immunity from lawsuits. In fact, Reagan's own administration opposed the bill. The official statement of administration policy said the administration opposes enactment. Should this bill be enacted, the president's senior advisors will recommend a veto. Reagan was essentially forced to sign it because it was bundled into a larger health bill. The pharmaceutical lobby had threatened to stop making vaccines entirely unless they got immunity, so Congress caved. But here's the kicker. The original 1986 law still allowed some lawsuits for design defects and manufacturing problems. The companies weren't satisfied, so in 2011, the Supreme Court in Bruce-Witz versus Wyeth gave them total immunity, complete protection from all design defect lawsuits. So if pharmaceutical companies can't be sued, who pays when people are injured? You do, the taxpayer. Since 1986, the Vaccine Injury Compensation Program has paid out over $5 billion. That's billion with a B. Your tax dollars paying for injuries caused by products made by criminally convicted companies who keep all the profits. Here's how the system works. Every vaccine has a 75-cent tax that goes into a compensation fund. When someone is injured, they file a claim in a special vaccine court run by the Department of Health and Human Services. But get this, there's no jury, no normal rules of evidence. The proceedings are sealed. 2/3 of all claims are rejected. And remember that $250,000 death cap? If a defective car kills someone, families can get millions. If a mandated pharmaceutical product kills someone, the maximum is $250,000. The companies don't pay a dime for injuries. They don't even have to show up to court. The government defends them using Department of Justice lawyers paid by your tax dollars. Now here's the smoking gun that destroys their entire argument. These companies claimed they needed immunity to feel secure making these products, but did getting immunity make them more responsible? Let's look at their criminal records after 1986. Pfizer's biggest criminal settlement, that record-breaking $2.3 billion, happened in 2009, 23 years after getting immunity. Johnson & Johnson's $2.2 billion settlement for targeting vulnerable populations? That was 2013. In 2012, GlaxoSmithKline paid $3 billion, the largest healthcare fraud settlement ever at that time, for illegally marketing drugs and hiding safety data. Just in the last 5 years, we've seen Purdue Pharma dissolved for creating the opioid crisis, Teva paying $4.2 billion for price fixing, multiple companies paying billions for their role in opioid deaths. Getting immunity didn't make them more careful. It made them worse, because now they knew that for one category of products, they could never be held liable no matter what happened. Let me ask you a simple question. If these products are as safe as they claim, why do they need immunity? Every other product in America, cars, food, appliances, toys, even other drugs from the same companies, face normal liability. Pfizer's Viagra doesn't have immunity. Johnson & Johnson's Tylenol doesn't have immunity. Only one category of products from these criminally convicted companies has immunity. We're talking about companies that have been caught, not accused, but caught and convicted of bribing doctors, falsifying safety data, hiding deaths, targeting vulnerable populations, and defrauding the government. These same companies now make products that are mandated. You're required to take them for school, work, travel. Yet they bear zero liability if something goes wrong. This isn't about any specific medical opinion. This is about a simple principle of justice and accountability. Why should the most criminally prosecuted industry in history be the only one with immunity from lawsuits? Even President Reagan, who was pro-business, pro-pharmaceutical industry, called this unprecedented and signed it with reluctance because he knew it was wrong. Every single fact I've shared comes from Department of Justice settlements, federal court documents, and official government records. This isn't theory. This isn't speculation. This is documented reality. The question is, now that you know, what are you going to do about it?